Before we begin, I need to let you know that I'm not a lawyer and the content of this video does not constitute legal advice. If you have questions or concerns pertaining to an individual issue, please consult a lawyer. Welcome to the first episode of a series on copyright. I was inspired to do this series because YouTube recently changed their strike policy and the issue of copyright has surfaced once more. Without further pretense or preface, let's get right to it. Number 1. Copyright exists from the moment content is created in a fixed form. Many people assume that copyright only exists once you register something you've created with the US Copyright Office or another country's equivalent. While registering with your respective government entity can't hurt, it's not necessary for copyright to exist. Copyright exists the moment your content is in a tangible form of expression. The U.S. Copyright Office defines this as something directly perceptible or in a form as it may be communicated with the aid of a machine or device. Under U.S. copyright law, a wide variety of works can be copyrighted, and the categories listed here were meant to be interpreted broadly. These categories include literary works, musical works, including words applicable, dramatic works and the music in them, notated choreography, pictures, sculptures, and other graphical works, films, sound recordings, and architectural works. Again, these categories were intended to be interpreted as broadly as possible because the government wished to encourage and not impede creativity. You cannot copyright names, phrases, ideas, methods, underlying concepts, or widely accepted theorems, or anything that is common knowledge. However, names and titles and short phrases can still be trademarked, so keep that in mind. Number 2. Fair use is fair use, except when it's not. There are a lot of misconceptions regarding fair use, especially where YouTube is concerned. Fair use is not one size fits all. What counts as fair use in one person's video will not necessarily apply to you in your video. Let me explain. U.S. copyright law and international treaties generally recognize fair use as the legal utilization of copyrighted content for the purpose of commentary, review, news reporting, scholarly research, parody, and/or education. However, fair use does not immediately apply if your content fits under one of these categories. Fair use is ultimately determined after considering these 4 criteria. 1. The purpose and character of the use. 2. The nature of the copyrighted content. 3. The percentage of the whole copyrighted work used. And 4. Potential market value of both the original and derivative works. Under these 4 categories, a for-profit parody advertisement might fall under fair use, while an ad-less reaction video may not. Fair use is only really decided by a judge and a court of law at the end of the day. It is implemented on a case-by-case basis and provides no blanket protection. Number 3. All plagiarism is copyright infringement, but not all copyright infringement is plagiarism. Merriam-Webster defines plagiarism as the act of using another person's words or ideas without giving credit to that person. Plagiarism is theft, pure and simple. There is no excuse for it, no grounds to justify it. Stealing someone's work is in essence violation of their copyright. In those scenarios, you are willfully distributing their content without their permission, a key tenet of the U.S. Copyright Act of 1976, particularly the portion that gives the copyright owner the exclusive right to distribute copies or phonorecords of the work to the public by sale or other transfer of ownership, etc. But what if you give someone credit in the video description? What if you say,
"No copyright infringement intended"?
Is that plagiarism? The short answer is no, it's not plagiarism. You gave credit to the person who made the original. However, you are still potentially infringing on the content creator's copyright. No copyright disclaimer in the video description will change that. If you do not have a written statement from the original content creator stating you have permission to post their work in its entirety, you are violating their legal right to exclusively distribute their creation. Typically, permission is given either through a license to use the work, such as what you'd see with a music library like Audio Jungle, Audio Micro, Position Music, etc., or a contract. Depending on the nature of the contract, permission may only be temporary, so be sure to read before you sign at all times. Number 4. Mailing yourself a copy of your work is not adequate copyright protection in a court of law. Known as the poor man's copyright, this entails mailing yourself a copy of your work so that you have a date stamp record of when you sent it. It's also a waste of postage. Remember, copyright exists the moment the work takes on a tangible form. Additionally, this method is no replacement for actual registration. While the UK is a bit more flexible on the subject of the poor man's copyright, this process does not constitute adequate proof that you are the creator. Registering your work with your respective country's copyright office allows you to pursue statutory damages in the event of infringement, but it can be cost prohibitive. Check your country's copyright office for details. Granted, this one rule doesn't apply to YouTube as much since everything's digital now, but it's still a good piece of information to have nonetheless. Number 5. Just because someone told you that you could use their content doesn't mean that you can distribute it to others. Picture this scenario. Pretend you contact me about your desire to feature my music on your channel. If I were to say yes, you could then upload my music in a showcase video. Simple, right? The problem is some folks take this one step further and assume the permission also allows them to distribute my music as royalty-free tracks without further attribution. This is seen all too often in music, film, and even books and short stories. A person sends someone else a manuscript with the intent of getting an opinion only to find it on a website blog later on. Just don't do it. It's not yours to distribute. When in doubt, ask the person whose content you wish to use for specific instructions. There are your 5 things to know about copyright. Just for kicks and giggles though, here's a bonus fact about copyright. Number 6. Music tracks sometimes have more than one right attached to them. Confused? I wouldn't blame you. This takes a little more patience to wrap your head around, but largely explains why using music on YouTube is such a difficult affair. A musical copyright is often a large conglomeration of multiple smaller rights that occasionally aren't even owned by the same person or organization. I'll save the nitty-gritty explanation for a different video, but long story short, you will often need to contend with 2 rights in particular, especially if you'll be making money off of the content you use. We've established that copyright is present the moment a work takes on a tangible form. Copyright law allows the copyright owner to assign or delegate certain aspects of that right to individuals and groups as he or she chooses. In most cases, this is usually a publisher. Typically, you will need to secure mechanical rights and synchronization rights in order to use some tracks. Mechanical rights deal with the right to include a composition in a sound recording. Then you need to acquire synchronization rights to then include that sound recording in a larger audio-visual production. Wish I could talk today. Just getting permission for one or the other isn't enough. You need both when applicable. Well, that does it for this video. If you found this content helpful in any way, hit that like button and let me know in the comments below what copyright information you found most useful. Also remember to subscribe to my channel if you haven't already. Thanks for watching. This is Bill Miller signing off. Until next time, lay on.